All right, so today I'm going to be talking about a motion for trial preference. What's a motion for trial preference? So, in personal injury actions, especially in Los Angeles, California, when you file a new personal injury action, typically you're not going to get a trial date for like another 18 months or so, at least. It's a big problem because you're just really waiting there just for the trial date. So, let's say that you are a plaintiff who is 80 years old and you are getting, life's advancing on you and you're getting a little bit more ill, and or even 85, 90 years old, and you need to see a trial perhaps sooner than 18 months. Otherwise, you could be limited in your ability to effectively participate in a trial. What do you do in that instance? So, California Code of Civil Procedure, Section 36, one of my favorite code sections. Yes, I have one. I guess I have favorite code sections now. You can file what's called a motion for trial preference, which means that once the motion is granted, that the judge has to set a trial within 120 days, about 4 months, from the date of the hearing. That could put extreme pressure, and it usually does. It puts extreme pressure on the defense, on the plaintiff as well, to get this case going, to get it done, to get it resolved. Otherwise, you're going to trial. And it's very difficult to continue that trial, to push off the date. In the code section, it says that it can only go by 15-day continuances at a time. So, whereas in other personal injury cases, if you file a motion for if you just have a normal trial date, you can push it off 4 to 6 months. Like 6 months at a time, or 4 months, 2 months, 1 month. So it's much more difficult. One, you have a very quick trial date, and two, it's much more difficult to continue that trial date. So it puts extreme pressure. So there are certain ways to get a trial preference. One is if you're over 70 and you have a substantial interest in the litigation, and it's in the interest of justice. It says it right in the code section what the actual language is that you need to utilize in order to get that. And a certain interesting caveat about the motion for trial preference, if a person is over 70, is that an attorney can write a declaration on behalf of their client based on information and belief. So why is that important? It's important because an attorney's declaration is going to be much more difficult, if not impossible, to use as evidence against a plaintiff, whereas a plaintiff's declaration, typically used in other code sections, other parts of motion for trial preference, that part as well, but the attorney declaration is available to you. A plaintiff's declaration can typically be used against the plaintiff later. Looking at it, saying, well, how long are you actually going to live for if you say here that your health is deteriorating, etc. So there are other ways of going about getting it as well. One is, showing some kind of clear and convincing evidence that a person is not going to be well within 6 months. So you typically need some kind of medical documentation or a doctor's declaration, something like that. There's different areas of the code section as well, but an important one is where it says that granting a motion for trial preference needs to be done in the interest of justice. That's a very good code section because it typically provides kind of a catch-all. So maybe your case doesn't fall within, maybe they're not over 70. Maybe you don't have clear and convincing evidence that the person is not going to survive within 6 months, but you still have a plaintiff. You're still in a situation where you need to get to trial within 4 to 6 months. I add that 2 months for the hearing date. And you don't quite fall into one of the categories of Code of Civil Procedure, Section 36. So that is available as well. I've used that section successfully. And it really depends on the circumstance. So if you are a plaintiff that needs to get to trial soon, perhaps you want to investigate whether you can obtain a trial preference and get that quick trial date and get the ball rolling. One thing I wanted to add is that with this catch-all, that might apply to someone who's sickly and not doing well, but not quite, where their life is on the line. So that would be available to them as well. So definitely check out whether, if you feel like you fall into this category, you probably should consult with someone who has knowledge of this area to see whether or not you're going to fit within the category, and perhaps get a motion for trial preference. Cautionary, just a piece of advice is that, once you get that trial preference, it's for me, I don't know of a way that you can get out of it. So you're going to be putting pressure not only on the defense, but on yourself, on the plaintiff and their attorney, in order to get the case resolved. So you want to be in a position where you'll be able to prove your case prior to getting that trial preference order. So if you guys have any questions, please ask in the comment section below, and I look forward to hearing what you guys have to say.